Okay. Good afternoon and welcome to part 4 of Schoeneck King's webinar series on data privacy and cybersecurity for higher education institutions. This webinar series focuses on the intersection of higher education and data privacy and cybersecurity. Today's discussion will focus on risk mitigation, incident response, and remediation in the face of a cybersecurity incident for higher education institutions. If you have a question, please use the Q&A box located at the bottom of your screen, and we will do our best to answer questions as time allows. Please remember to fill out the questionnaire following this presentation. Today, we are pleased to welcome Seth Gilbertson to our series. Seth is Senior Counsel at Schoeneck King, where he specializes in representing and advising institutions of higher education on labor and student affairs issues. Prior to joining Bond, Seth was senior counsel at the State University of New York, where he was the primary counsel responsible for 5 campuses and several practice areas, including international programs and applied learning. Seth is an active member of the National Association of College and University Attorneys and the New York State Bar Association. Thanks so much for being here, Seth. Joining Seth is Jessica Copeland. Jessica is chair of the firm Cybersecurity and Data Privacy Practice Group and a certified information privacy professional for United States data privacy law. Particular to today's presentation, Jessica's broad experience includes advising clients on data privacy legal compliance, defending clients in data breach class action litigations, and routinely managing data incidents, breaches, and advising on breach notification obligations. She has particularized knowledge on compliance with New York SHIELD Act, California Consumer Privacy Act, and the General Data Protection Regulation. Thanks so much for joining, Jessica. I'll kick it over to your team.
Thanks, Amber, and thank you everyone for joining today. We hope to provide you with some background information on what your obligations would be in the event of an incident and hope you can prepare for that day that no one wants to come. Next slide. So just a quick overview of what we're going to cover, and more specifically today is we'll talk about the key definitions. As many of you know, the law is based basically on what terms mean, what a term means in a particular statute or regulatory reference point. And so we want to give a little more depth into when we say data breach, what that means. When we talk about personal information, what that means. We're also going to discuss common types of data breaches and what we are seeing in higher education institutions that have suffered from data breaches. Then we'll talk a little bit about what that breach response strategy should entail and how you can implement policies, procedures to best address an incident once it happens. Next slide. So key definitions, personal information. This is a very broad definition, and you'll find this in most applicable data privacy laws. It's important to take a moment to mention that we're going to focus specifically on New York State's data privacy law when we talk about definitions and what they mean. But if your university or college does have a data incident that rises to the level of a breach based on the definition of data breach in that statute, that analysis is triggered by the state of residence of either the student or employee that is impacted. So although there are state-specific data breach notification laws, most of the definitions are similar. So personal information would include any information that basically can identify an individual. The important piece to know is that just an incident that includes someone's name or address, if we're talking about a United States resident, typically will not trigger an obligation to notify. It requires that next level, which is where private information comes in. This definition is right out of the New York SHIELD Act. And like I said, it's similar to most state breach notification definitions. Private information is any of that first category of information, that identifying information, plus a social security number, a driver's license number, or some other identification number, or financial account information, credit card information, if access to using that credit card information is available, meaning was the credit card number compromised with that 3-digit code that allows you to have transact business. Biometric information. So if you have a system where students are able to log in with their facial recognition to get into their school issued laptops, or perhaps you take fingerprint information to get into certain labs on campus, and you're storing that data somewhere, that is considered biometric information. And if there's an incident and a compromise to the computer system that's holding that data, and that data can identify student name as well, then that would trigger notification. And then finally, if there's a cyber intrusion that allows for access to a username and password for online accounts, think about shopping accounts or Worth bank accounts, that would also trigger notification. I also want to take the time to mention that Seth and I would really like this to be a dialogue, although it's a little challenging in a webinar. So if you have questions, please put them in the Q&A box so that we can address them as we're going along. And then finally, the definition of a data breach is, again, broad. We're going to talk about this a little bit because it now allows for a data breach to include access to information. Several years ago, most definitions required acquisition and actual taking of data from a computer, a downloading of information. The fact that it is broadened to include access to computerized data that would compromise the security of that information opens the door to many more reportable breaches, including what is one of the more common examples of a breach called a business email compromise. Next slide. So the common data breaches we are seeing are inadvertent disclosure. So this happens, unfortunately, quite often, where you have somebody that's working really at a fast pace, trying to get information out to constituents, to donors, to student body, and they accidentally send a broad scale email with student information in a spreadsheet that's not encrypted. So that can impact many individuals throughout the university, and we're seeing that quite often. So the best way to mitigate against inadvertent disclosure is, frankly, training of employees. And we'll talk a little bit about that later on today. But in addition to that, we're also seeing the traditional malware and ransomware attacks. So malware is where so mal means bad, ware is like software, but it's bad software, and it invades your computer systems. And in some instances, there are cyber criminals that can enter your system and basically do reconnaissance for months before they deploy something that's more abrasive that would be noticed, such as a ransomware code. So the malware can, sort of watch your activity, see where weaknesses in your network might reside, and then can be exploited through something a bit more significant, like a ransomware attack. And then phishing emails, unfortunately, are still one of the most prevalent forms of cyber intrusion that results in a data breach. Next slide.
All right, can we stay there for a second?
Oh, sure.
I want to take you up on your offer to make this a dialogue-based program and ask a question of my own. And I probably could have warned you about this question earlier because I thought about it, but then I forgot until just now. We've all been reading a lot about about AI lately, chatbot, those kinds of things.
Yeah.
How do you? I'm sure you put some thought into how that is going to affect maybe many of these types of breaches, but it seems to me that particularly phishing. I guess when I read social engineering and that, I think that computers are going to get good at engineering us pretty soon, and maybe be better at phishing than at some of these phishing attacks than the traditional cyber criminals may have been.
Certainly. Yeah, and whether or not it's something that is built by a chat GPT or simply just a very sophisticated cyber criminal that has learned through intruding on an organization's email system how to formulate an email to really catch someone. And I say it that way because we're no longer in a world where you have a strange email from a country that you've never visited that's asking for money, right? We have emails that even the email address that it's being sent from is legitimate, because you have a cyber intruder that gets into the email system and sends the email directly from that person's inbox. So it's not even as, the use of an AI that can do it, but certainly I could see ChatGPT being exploited in that way, so that, or something similar, so that you're learning what an organization's email practices look like, and then going to manipulate that and social engineer it to goat somebody into responding and potentially changing, an ACH account or transmitting funds in some way, or learning where, if you get into an IT director's inbox and you're navigating to see what network solutions exist in that organization, now you might have a roadmap into how to deploy more malware or actually endeavor a ransomware attack. But the point about AI tools, what I look to and what I've been thinking about is warning clients, and in particular, all law firms, all legal departments, not to be putting confidential information. It sounds like it's such a traditional or rudimentary concept, but you're basically sharing confidential information with the public. There are no security measures surrounding that tool or similar tools. And so it's really important to, if you are going to use it, and I do think there are uses for it, to use it smartly in an anonymous way where you're not sharing information that could either share trade secret information of a company or secret information about how your security is protected and your organization.
So we all thought that the robots were going to take over with indestructible androids, but really they're just going to use tricky email.
Mm-hmm.
That's what I'm hearing.
That's right.
On the inadvertent disclosure side, I just want to make a little prompt here. One of the things that also happens, Jessica gave some good examples of places where inadvertent disclosures occur. Another one is where things just happen to end up on the wrong side of your firewall somehow. And I know a lot of colleges and universities, I hope a lot of colleges and universities are working on scouring their websites and cleaning up particularly things like PDF documents for accessibility purposes. As you're doing that, you can also be looking for some of those documents that shouldn't even be where they are or on the wrong side of the firewall. We've run into that multiple times where you're really looking through those documents for one reason. You go, hey, wait a minute, why is that out here in the first place? That shouldn't be out here. That should be someplace else. So yeah. Just, might as well make use of the time and efforts. And if you're training people like GAs to go through and clean up PDF documents and things like that, make them readable, also have them looking for potentially personally identifiable information and things like that should not be out there.
Thanks, Evan. And I see an anonymous question. Is it a data breach if a threat actor gets access to an email account that has private information somewhere in the many emails, but we know the threat actor did not forward any of the emails or download the emails? They could have taken screenshots if they found private information. Is this what you described as a business email data breach? So the answer is possibly. And when we evaluate whether this rises to the level of a breach without definitive information reflecting that the threat actor was able to view the particular emails with social security numbers, if that's what you're referring to, or potentially PHI, we would need to assess how long the threat actor was in the environment, but also just an understanding of what volume of personal information or private information resides within the size of that email account, and how likely it is that they could have stumbled upon it or ran searches to find it. Because access alone would say, yes, that is still a data breach because they did technically have access. But the risk of harm that you would also want to analyze to determine whether it's reportable, it comes from the likelihood or unlikelihood that that particular information would have been accessed. So it's unfortunately, the answer is it's a gray area. It depends, but on the face of your question, it is likely to be considered a breach under any law that says access alone is sufficient. Thank you for the question. Okay, let's go to the next slide, please. So what would a data breach in a higher education framework really look like? So it could be, through malicious code, hackers gaining access to information, or it could be lost devices if you have faculty traveling and they keep their, again, organizational issued or higher education institution issued device with them that gets lost or stolen. Employee negligence. I always come back to train. You cannot train employees enough. Human error is literally the number one cause of any data incident or breach. Policy and or system failure. So do you have a patch management policy that requires the rollout of patches to your servers or other network solutions on a timely basis, and who is running that program? Because if there's a computer intrusion that's not the result of a well-executed phishing attempt, then it is through the exploiting of a vulnerability in your network, either through not updating your firewalls appropriately or patching outdated systems. Next slide.
I wish we had a poll here, because I'd ask how many people in our audience remember SunGuard, and I can feel people shivering as they see that. That was if you recall, a lost laptop, or a laptop that I think was left in a contractor's front seat when he went into Starbucks and stolen, and it sent shockwaves, for many of you will recall, throughout many institutions, particularly in the Northeast. And I was thinking about that the other day when we were preparing for this, and thinking about what if that happened today, because that was 15, 20 years ago, when laptops contained nowhere near the amount of information that even a cell phone contains today. Right. Most people still had a desktop computer and they just used their laptop for travel, and there were only a few files on it. That kind of thing. Now everything is on smaller devices. If it was an actual laptop, it would probably have all of your work information, all of your records on it. So I just wanted to remind people of that, because I had to think about it myself. So I figured I'd have some people join the suffering.
Very helpful, Seth. Thank you. So why are colleges and universities such a good or valuable or easy target for a cyber attack? And the answer is the retention of large volumes of data within your computer systems, your backup systems, frankly, your vendors' backup systems. And so the one breach that I think of, Seth, that makes me shudder and we're still feeling shockwaves from is the Blackbaud breach of 2020, which impacted universities, colleges, not-for-profits, both domestically and internationally, and resulted in significant fines just recently by the SEC. And part of that compromise was that they were running outdated backup systems to store their client data. And so when we talk about risks that higher ed institutions are facing, it's not just what your IT department is doing and what your network looks like, it's what all of your vendors are doing with your data and what their network and practices look like. So just a tidbit to keep in mind. And so in any event, the records retained include frankly, the most valuable information to a cyber criminal, which is social security numbers, identification numbers, and financial information. In 2022, ransomware attacks that targeted higher education institutions averaged $2.7 million in recovery costs. That is not insignificant, no matter what the size organization you work with. And ransomware response costs were about 1.8 million on average. And what that would entail is whether or not there was a payment of a ransom to a threat actor, which obviously impacted those numbers. The higher average costs for higher institutions, higher education institutions, are in part because you have different departments that are handling different data in maybe a not uniform way. And when Seth goes into crafting and revising policies and procedures, that will be addressed. And then you also, as I mentioned, having outdated systems that don't have the most recent security protocols to protect data can definitely result in vulnerabilities. Anything to add there, Seth?
I just point to the second line there, large amounts of student records. I know certainly in the healthcare side, people think about this all the time, how not only do they have a lot of data, but a lot of that data is legally protected. Same is true, and I'm not telling anybody out there in the audience anything they don't already know, but same is true for many, many, many of those student records. Those have a higher degree of protection than the average business or industry or sector has to deal with. And that when we end up doing a forensic analysis and looking at what was breached, a lot of it seems relatively routine to us, but we have to remember it's going to be legally protected, certainly under federal law, possibly under state law as well, even if it's something as simple as, you know, somebody's transcript from 1993 that they don't really care about. It's still going to be protected. Somebody's class enrollment history, things like that, emails with faculty members, things that have very little actual significance are still legally protected and still will trigger all kinds of sort of cascading legal obligations on behalf of an organization, which increases that cost that Jessica's talking about. Tends to be very high in our area.
Thank you, Seth. Next slide. So some of the recent data breaches we're seeing reported by higher education institutions are listed here. I won't go through each of them, but you'll have them in your materials. And it's just a good reference point to see what are real examples of a breach that caused harm to an organization. So the most recent is obviously this month, University of Hawaii reported an unauthorized access to almost 11,000 student records that had confidential information, and they were required to report it. That's how we know about it. You know, anything in these slides is publicly available. March of 2023, Our Lady of Lake University had to post notice of a data breach on their website, which occurs when so many impacted individuals need to be notified. And if an organization does not have contact information to share that notice with, then you're forced to make a public statement, which can be harmful in terms of your reputation. So, you know, unfortunately, those situations happen. It's referred to as substitute notice. And it looks like the sensitive information that was compromised included social security numbers, bank account information, government ID cards. And so I'm sure that was not a happy moment in the legal department or in the compliance or risk department for that university. February, Stanford University had to send breach notification letters to just about 900 individuals whose health information was downloaded from their systems. So as you can see, with just the last 2 months or 3 months, there are at least 4 reportable breaches that we identified. This is unfortunately an active place for cyber criminals to be trying to target, and there's no better time than now to make sure that your network, your IT systems are up to date with all security patches, and your practices include the right level of multi-factor authentication and user ID information. Next slide. So responding to a data incident, and what does that look like? So you have to detect the incident. How does that happen? Well, sometimes it's that an alert employee receives an email from somebody that just doesn't sound right, and they report it to their IT director or director of HR. Perhaps it's that doomsday event where your administration office tries to log in one Monday morning and they receive a ransom note. And what happens? In order to address the what happens, you need to have an incident response plan. And that plan should include who that incident response team is going to be. The team should comprise of someone that can address any human resources issues, so certainly a director of HR, director of IT. Often it's the CFO or director of finance, because if it's a ransomware attack, now we're determining, do we have insurance? Do we have budget to cover this investigation? Do we have budget to even think about paying a ransom? So the response team is a really critical piece of what the response plan should be. And in the immediate response, if it is a business email compromise, the email account that is identified as having the compromise should be disabled. Frankly, all passwords and login credentials should be changed across the organization's Outlook or Google account, because it's hard to trace when a cyber criminal gets into that email environment where they may have laterally moved. And so you want to be able to basically hard reset so that the criminal no longer can have access to it. And then if there is a ransomware attack, you want to try to quarantine, is called, the impacted server, take them offline so that there's no longer connectivity from where the threat actor has gotten into, and make sure to have backups that are separately contained with encryption that would not be able to have access if your everyday server is compromised. Seth, anything to add there? Nope.
No, just I guess the breach response team, and I'm going to talk about this a little bit later, but I see this as sort of a tiered approach. There's your core team, and then there are sort of auxiliary or ad hoc members that should have a greater than average level of knowledge about your policies and procedures and plans, but are maybe not part of your core team. So I just want to encourage institutions to think about who those people are. And again, I'll talk about it a little bit more later, but some areas that those may also include some of those vendors that you spoke about earlier, a primary contact at your food service vendor or someplace like that, who you're exchanging financial information with, right? So it's not just software vendors, it's all kinds of vendors all over campus. Absolutely. But just thinking athletics, student conduct, the engineering department, there should be somebody sort of at the head of every major silo that at least who to reach out to. They're not the first time that you call them about a potential incident is not the first time they've heard about this process and how it's supposed to work. They may not be in every meeting, they may not be always involved, but there's sort of at least a dotted line there, and they have a greater than average level of knowledge and competency when it comes to these types of issues.
Absolutely. And one of the most important pieces of developing and implementing an incident response plan is to practice it. And that's called a tabletop exercise that really needs to take place. It's a living policy document that should not be stored somewhere in a file or a cabinet and never looked at again. You need to make sure that what you're sketching out as an incident response plan is actually effective for the way your organization is run. Next slide.
Jessica asked me when we were preparing for this, how many of those tabletop exercises I had personally participated in. And I think my response was something like, I know that there were a lot of them on my calendar at various times. I don't know how many actually happened. And so, that happens to a lot of things on our calendars. We're all very busy, but I think taking her advice there and making that a high priority event on your calendar is appropriate. And if you take nothing else away from this, that's a good nugget of information there to sort of put that at the top of your priority list or way up there anyway.
Absolutely. And you'll find so we're going to talk about who you should call and who should be the top contacts within that incident response plan. And I always refer to contacting your insurance carrier, because if you haven't cyber security insurance, you might have the type of insurance that you need to call them first before you start engaging legal counsel or forensic team. Otherwise, you might risk not being covered. So it's really important to understand the scope of what that cyber liability insurance looks like. And certainly you should have, if you have in-house counsel or if you have a reliable outside general counsel that you go to for corporate matters, you should work with them directly to engage the forensic team, even if it's an engagement of a team that is recommended by your cyber insurance, because that will help to protect the investigation under attorney-client privilege. So really important to contact insurance carrier, identify a forensic team and a cybersecurity counsel that can help navigate what that response looks like, what the investigation looks like. Because part of the investigation, although it is heavily technical, should be steered and guided by an attorney who understands what the law is saying in terms of what's a reportable incident, so that you're not, spinning wheels or wasting funds on an investigation that's not really going to, at the end of the day, tell you, okay, do I need to report this and who do I report to? You don't want to lose sight of that while the investigation's ongoing. Next slide. Okay, so the notification procedures and obligations. I mentioned earlier that we are going to focus on New York State's data breach notification law. However, every state has their own obligations and parameters that trigger who you need to report to. So at least within New York, if you determine that it is a data breach, you need to notify the individuals impacted by the breach, and it should be in the form of a letter that describes what the incident was and what measures the company is taking to remediate and potentially, not have this occur again. And then in New York, there's no threshold for when you're obligated to report to the Attorney General's office, the Department of State, and Division of State Police. So that needs to be taken care of regardless of whether it's 5 people or 5,000 individuals. I say it that way because certain states do have a threshold. So there are examples where if you only have 50 individuals in the state of Georgia that need to be notified, you might not need to notify the Attorney General. And then in New York, if more than 5,000 New York residents need to be notified, then the consumer reporting agencies also need to be notified. Next slide.
I'll just say with regard to that, and as I move into this slide as well, you may not be in New York, but you may have students here, and you may be in New York, but you may have students elsewhere. And those obligations are oftentimes going to travel across the interwebs to give you obligations in states where you may not be physically present at times. So you want to be looking. We're talking about New York as sort of an example. You should obviously be looking at your own state laws that may be analogous to some of the ones we're talking about. But you also have to consider the New York laws. And if you're in New York, you also have to consider the laws of other potential jurisdictions that you may be subject to based upon various activities, including remote and hybrid learning. And with that, I will talk about, so there are some, there is a breach notification requirement under the general business law. There is a similar requirement for those of you that are public institutions that you know about in the state technology law that reads almost exactly the same way. In addition to that breach notification requirement that talks about when you have to notify individuals, there's also requirement that you notify particular regulators. I can tell you that both on the, I'll just mention the New York side very briefly. Technically, and I say this technically because I've been involved in a few of these and I've never actually seen anything come of it. It doesn't mean that it will never will, but there is a requirement that educational agencies notify the New York State Education Department's Chief Privacy Officer. And in fact, they have a form that I believe is going to be part of the materials that you're supposed to use to submit your report. Again, I'm not sure. I lived in Albany for a long time. I never saw where those reports went. And I'm not sure that a lot of people know, but there is a reporting requirement submission for educational institutions. And many of your states outside of New York are going to have similar requirements, particularly if you're a public institution. I'm quite sure that there's a high likelihood you're going to have some kind of internal reporting requirement through your state regulators. On the federal side, it gets even a little bit more blurry these days. There is a federal office of data privacy in the New York State, or I'm sorry, in the federal student student aid office that requires a submission of particular information. It's nerve-wracking, I can tell you, to make that submission at times. And it's probably even more so now than it used to be, because the person who was in charge of that office for a very long time and did a lot of speaking and was very accessible is now gone. I'm not sure who the person there is now. So when you send an email to the privacy CPSSAIG@ed.gov, I don't know who's going to receive it. I can't tell you that. I can't tell you what they're going to do with it. I can tell you that sometimes nothing seems to happen. That doesn't change what your obligations are, but it is, again, a bit nerve-wracking. The requirements are that you generally send the date of the breach, suspected or known, the impact of the breach, including the numbers of records and what types of records, the method of breach, whether it's a hack, an accidental disclosure, etc. The information security program point of contact, email and phone details. Again, I've been that person before and never received anything back, so I don't know. It doesn't mean you don't have to do it, but again, I'm not sure where the information is going, and when you're sending this information along, it's a bit nerve-wracking when you don't know where it's going, but it is, to the best of our knowledge, still a requirement. Hopefully there'll be some as the administration gets a little bit more comfortable in this area, more things are happening. Maybe we get a replacement in the privacy office and we get some greater clarity and guidance around what we're supposed to be doing. But finally, you're also supposed to report remediation status and next steps. So you basically have to give them your plan. As with many of the requirements where we talk about, and as Jessica spoke about earlier, sometimes you don't know enough to be able to report these things. And you really just kind of have to do your best. You know that there's been an incident, you got your team together, but in terms of what the next steps are, all the answers to all the questions that I just gave you, you don't know a lot of that stuff for quite a while sometimes. So, I've taken the position that we can't report something we don't know. So you really have to figure out that information and have a pretty good handle on it, which I guess gives us a little bit more security, a little bit more comfort in sending that information, and that a lot of times we do have our arms around the situation by the time we're sending that information to regulatory authorities. But Jessica, do you have something to add?
Yeah, it's just important to know that it's quite common to want to report right away, as Seth was saying. But my question is always to the client, who are we reporting to and what are we reporting? Because we really just don't know. It's so hard to identify. It takes time to identify the impacted individuals and the impacted data categories. to know whether or not it is even reportable. So just keep that in mind. And this is where that exercise, that tabletop exercise helps, because it'll make it a little less traumatic if you've gone through that practice when it actually occurs.
Yeah, I've been in that situation where it kind of feels like you're hiding something, but
yeah,
the fact is you don't know what you're hiding because you don't know what it is that you're supposed to be disclosing, because you haven't quite identified, you don't have your arms around what the problem is yet. You know, there is one, and that's about all you can say. And
right.
that's not going to help any regulator to report, hey, we know that there's something going on, but we can't give you any of the information that you need to do anything about it, or to even make sure that we're doing what we're supposed to be doing about it. Finally, I want to add, although not on this slide, that there are also FERPA requirements related to not necessarily notification, but keeping a record of disclosures. So as you are identifying FERPA records that have been potentially inadvertently disclosed or breached, you should be noting that somewhere, keeping a record of it. Probably that's going to be in most cases in your registrar's office, where you have a sort of a log of record access, and that's where you would log it. But you want to make sure that you're doing that to some extent, that you are keeping a record of the disclosure, even if you determine ultimately that you don't have to make a notification about the disclosure. Next slide, please. All right, international law. I'm not going to spend a ton of time on this. I wasn't going to spend a ton of time on this anyway, but looking at the clock, we have even less time to talk about it. This is probably a webinar of its own, frankly. Under GDPR, as this says, you generally have 72 hours. Again, the clock starts ticking. We're not exactly sure when. It's going to depend on what information you know and when you know it. One of the things that I think this does trigger us to think about, though, are particularly with regard to GDPR, but also PIPL. When we learn more about PIPL, I think it'll probably tell us this, that things like foreign campuses, foreign activities, study abroad activities, and even international student services offices are places I mentioned earlier, sort of team members of the team that may be kind of ad hoc or dotted line members. A lot of those offices, you know, if you have a dean of your foreign campus, or director of study abroad, or the director of the international student services offices, those kinds of people are going to want to be involved in this. And maybe one of their assignments sometimes is to keep up on, not only keep track of who they have where, because that's gonna some of your obligations are going to turn on that factor, but also, you know, the latest information on what your partners in those countries expect. I don't expect, you know, the director of your national student services offices to be an expert in GDPR, PIPL, or any other foreign data privacy law, but to at least know what their partners are expecting of us, because a lot of these things, particularly what we already know with GDPR, are going to be in our agreements with those partners. So just having those ready at hand so they can show those to us and put those in front of the team, so it's part of the universe of information that we're considering. Next slide, please. All right, so we'll go next. Thank you. We have sort of a three-tiered approach to policy development in this area. The way that I look at it anyway, you have a policy, which is the high level data response, a lot of the things that we've been talking about, a lot of the things that you should have prior authorization for, appointments to teams, the kind of things that you're going to go through. You have authorizations, you have individuals, you have types of information, types of data that you're storing, and types of potential incidences identified and what the responses are. That's going to be pretty well publicized. Those are definitely going to be things that second tier of individuals that may be involved in responses are going to be particularly aware of. Everybody should be aware of these to at least to the extent that they are able to recognize and report potential incidents. I think that's really, not everybody needs to know, who your cyber insurance carrier is and how to notify them. Everybody needs to know, oh, shoot, I had this, somebody got access to my email. I lost my laptop. Some phishing activity has been going on in my data store, in this data storage area. Those kinds of things are important for everybody to know about and know when to report. It's kind of like Title IX in that area. Not everybody needs to know how to run a hearing process, but everybody needs to know how to identify sexual harassment and where to report it. Everybody needs to be able to identify when you have a potential data incident and where to report it. Next slide, please. The next sort of level in the tiered approach here, I'm going to go kind of fast on it, is the procedure. One level down, really. It's still a pretty high level strategy for your response, but it's going to identify exactly who does what. It's going to have prior approval for those people. I think this is a really important aspect, particularly if you need board authorization for anything. It may be much easier to get the president on the line or the VP on the line to authorize something. Getting the board together to authorize somebody to do something, particularly if it involves expenditure of funds or something like that, execution of agreements, things like that, notification of authorities. You want to have those things all prior approved. And that's going to be, specifically identifying who those are and keeping those up to date as you have personnel changes and things like that. Reorganizations are going to be important aspects of this. Next slide, please. And then finally, you have what is kind of the what I would describe as the division level approach to it, where each division, each department, each area, maybe each vice presidential level is sort of looking at this and determining how the policies and procedures are going to apply within their department, who's going to be responsible for what, and that they're going to be involved in some of those tabletop exercises. You're going to have specific people identified to do specific tasks, and to also be able to know about their own area. I mentioned earlier, knowing what's in your MOU with your foreign campus partner, that or your foreign institutional partner, things like that. And knowing those things are going to be things that are on the sort of the plan level. Next slide, please. And then finally, for me anyway, information management, records retention, huge part of this. Probably the area that gives me the most trouble sometimes, because I can tell you every time I've ever been involved in one of these incidences, when we find out the information that was lost, the information that was breached, the information that was potentially breached, the information that went somewhere it should not have, there is almost always information included in that data, included in that we didn't have to have in the first place, or that at the very least didn't need to be where it was in the first place. So having clear records retention schedules, it says here that the internal policy should establish when things must be deleted. Generally, you're going to set a minimum, but then you're going to enforce that minimum and say, unless you have a really good reason, the minimum is the number that should apply. So the only real reason is when you have some kind of a legal hold in place, or an operational hold in place, or maybe you have an archivist doing work on some particular document set, so you have a hold in place on that. Otherwise, you stick to your retention schedules. The people that stick to those retention schedules need to be identified. People need to have specific, not only authorization to clear out that data, to destroy data when the retention schedule is up, but to have that as part of their responsibility. And I always say, put it in your performance evaluation of that individual, because people pay attention to the things they're being evaluated on. If it's just sort of an out here or something that you're supposed to maybe keep track of someday, it's going to get lost. It's not going to get transferred to the next person that takes over that position. So if it's not in the position description itself, it's at least in a performance plan at some point. A supervisor knows to ask about it, knows to think about it. That's important. And then on the enforcement side, I think every institution needs to have a records management officer. That can't just be a tag along title that they have. It has to be an actual job, where it may not be their only job, maybe they're also have other compliance obligations, things like that. But where records management is a significant part of their job, and going around making sure, training custodians, working with custodians, updating retention schedules, monitoring those, making sure they're being adhered to, are important things. One final point, I know we're running short on time here, but one final point I want to make here is custodians keep information, not only are the ones who keep the information, but they keep the information in the right place. The right place, and this is, I just have to say this every time I talk about information about records management in higher education. The right place is not a private email account. So if you have faculty members that are automatically forwarding their .edu information to their Gmail account or something like that, you gotta stop that now. I know it's hard. I know faculty don't like to hear it. I know change is hard. I know enforcement is hard, but that is a sort of low-hanging fruit in terms of an important thing you have to do. I know it's a big hill to climb sometimes, particularly dealing with faculty. I hate to pick on faculty, but they're the ones that are going to be most resistant to that. Generally, the assistant athletic director is not going to give you a lot of pushback on that. It's going to be the history professor who likes to use their Gmail account and doesn't like to use their .edu account, and refuses to abide by what is a pretty important and base level policy. So with that, I'll turn it back over to Jessica for the last slide.
Thank you. Next slide, please. Thank you. So part of your best practices should also include security measures that need to be in place, and those are broken down into 3 categories: administrative, physical, and technical safeguards. We talk about administrative safeguards. Certainly you need to have a written information security plan. That's an internal policy that dictates what type of patch management policy you have, what type of acceptable use policy you have, generally speaking, how your organization handles personal information. But most important on this list, well, they're all equally important actually, but workforce training, it is the most significant piece of your administrative security safeguards that you can implement. Incident response plan, we've talked about ad nauseum. Business continuity plan, also critical. You should have a doomsday, what happens if we can no longer access any of our data? What do the backups look like? Can we rely on our backups, or are we rebuilding from scratch? And so do we have physical files, and how old do they date back, so that we can rebuild our data folders that we are required to retain according to the retention schedules that Seth referenced earlier. Physical safeguards would be actual physical security surrounding where your server rooms are, what your security, do you have locks on every employee's door, and where are the files stored? Is sensitive educational records stored in a file cabinet with a lock? Building access and control. And then the technical safeguards are actual access to digital files. And is that, broad across the organization? It shouldn't be. It should be limited to the individuals in the departments or the silos that need to have access to that particular information. Certainly, any sensitive data that's transmitted should be encrypted, meaning it should be password protected or sent through encrypted manner from one email account to the next. And then you certainly need to have, as I mentioned, your backup controls, meaning you shouldn't have the same passwords and credentials to access your backup files as you do to the live files that you're working in day to day. Multi-factor authentication, probably the number one simplest security measure to roll out. I know it doesn't sound simple. You'll have probably, if you don't have it in place already, much backlash, but it's just something that people need to get used to, because it is an easy measure to mitigate the risk of a successful phishing exploitation of credential stealing. I do think we may have run over. Initially, Seth and I thought we had an hour, and I think we actually only had 45 minutes. So thank you everyone for the questions. And if you have any follow-up questions, Seth and I would be happy to address them. Feel free to contact us by phone or email. Also feel free to find us on LinkedIn. It's been a pleasure. Anything else you want to add, Seth?
Nope, I just want to thank you very much for letting me tag along. And thanks everybody for staying with us.
I see a Q&A. Oh, the presentation, I do believe it will be shared, Hush. Thank you. Thanks, everyone.